Votes taken will be done by roll call because this is a remote meeting. And it will start with roll call attendance. Bill Ambrosino here. Lonnie Tinio.
Lisa Hill.
Aye.
Lisa.
Aye.
Brendan.
Here, aye.
Liana.
Here.
Okay, I think that's the only members that need to have a roll call. So I will just note that we have Gabe Trevor and Jane Wynick from CMRPC on board, and we have Planning Department, Mendon's Planning Department, Jack Hunter and Dylan Lindholm. Sorry, Dylan, aboard. So with that attendance in the record, let's move on. So Gabe, I'll let you take it away. Where'd we leave off? I wasn't here last meeting. I apologize. Didn't get a chance to review the tape, but
yeah, no worries. So I think for today's session, we're going to begin to review Article 3 of the zoning bylaws. We've done some talking about the other two articles in addition to looking at, potentially a revised parking bylaw. I think there's more. I think Jack, Jane, and Dylan and I are going to work on putting together, a more coherent revised parking and signage bylaw to bring to the committee eventually, just because that's a more in-depth process. And additionally, we also started thinking about what a village center zoning bylaw could look like. But like we discussed before the meeting started, I think it makes a lot of sense to just finish the existing zoning bylaw before we get too in depth, get on too many tangents with new things.
We're obviously on a timeline here. We got 6 months to get this done.
Right.
And I want to make sure that we get it done. And
right. So I'm going to screen share Article 3, and I think Jane and I both reviewed Article 3 in depth. And we have a bunch of different notes on the article, and so we'll just go through them, and if anyone has any thoughts, we'll be sure to put them in this document and make sure that's saved. And I think, but just because we do have a lot to get through tonight, I want to try to keep tangents to a minimum. So share window. Yeah. 12:30.
Gabe, that's all the fun. The tangent.
Can you blow that up, Gabe?
Yeah.
I'm getting a little older now. It's a little more difficult for me to see things.
Absolutely, no problem.
Why we got glasses, Bill.
That's what I'm
There you
right
go.
now. Put it on
So,
right now.
Article 3, use regulations. I think the first, we have a thing about you have to follow the table of uses. That makes sense. Moving on to prohibited uses. Any use not specifically or generally listed in the table of uses shall be deemed prohibited. No use that is prohibited shall be allowed as a principal or accessory use. In addition, the following uses are specifically prohibited as principal and/or accessory uses in all districts. Airports, and then the first place where we have a comment: mobile home, recreational vehicle, camper, or trailer camps or parks. No mobile homes, trailer, RV, or camper shall be used as a permanent residence. So Jane highlighted that. Review this to determine if this is legal. The term permanent is the key word. Some communities allow these for temporary use. To be used as permanent residence, it would have to meet state building code, i.e. not on wheels, okay to leave as is. So since these would be things on wheels, different from, manufactured housing, this would be okay to have this. Though I do think getting the language down around mobile homes and RVs, because those are still things people park on their property, and making sure also that there's provisions if there's some sort of construction going on the property, that's like a use that can be accommodated. And I think like 30, 90 days, and maybe with like the option for the planning board to extend it if necessary.
Just a note, right now, there's a
Yeah.
mechanism to, the select board can grant temporary licenses for those that might be, I know that we had a couple where people were building homes, and we probably let them go way too long, but they eventually get done, so.
Yeah, I mean, there's always instances, someone's home burns down. Generally a temporary residence or a temporary, either mobile home or RV or whatever have you is used as a temporary residence in those circumstances. So, but I think this covers it because I mean, that still doesn't qualify as permanent residence. So,
Yeah.
I'm good
Moving
with
on.
it.
Okay. Moving on to fur farms and piggeries.
we're still on this. Oh, geez.
Jack asked that we look into why these are singled out. Also look into what is exempt under ag laws. Per group discussion, animals such as mink produce a strong odor. Should we consider creating a separate category for fiber-producing animals such as sheep, llamas, alpacas, and rabbit? I didn't know rabbits were a fiber-producing.
Oh yeah, Angora,
Oh, okay, yeah.
I think.
My point was, Bill, there had to be, or Lonnie, there had to be something going on that brought this about. Why would you single out fur farms of all things?
You know what? There's been a couple instances in town where, like, I think number one is sheep, and sheep can put off a serious aroma. Same with the piggeries. I think it was we had both in Mendon, and when you drove by, you knew it. So I think that a lot of that was derived from that, but
Eh,
I think these uses are exempt under the agricultural use anyway.
Yeah.
I'm
It
not
is.
Yeah,
sure.
per the definitions of the general right to farm general bylaw, fiber animals are included in the definition for farming and agriculture.
So I'm not sure. I'm
If
not
it's
sure
already exempt,
why
should we
they're in
strike
there.
it?
I mean, that
Yeah,
was
I feel like we should strike it if this is if we
It's
want to.
exempt. It's
Yeah, if we want to say it.
clearly.
Liana?
Yeah.
I was just gonna say, I'm just curious as to why we would strike it. Are we having issues with these? Because it does say, except to the extent it constitutes an agricultural use, and I think
Yeah, I would just leave it because it's outlining
Mhm.
the right to farm bylaw. So
Okay.
Yep.
My only comment, Liana, on that is why single out fur farms then? I mean, why not have some other, I mean, that seems singling out is not good for a zoning bylaw and it's exempt.
But I,
We
I,
could
I agree with Jack on this, that we're only taking two things out of the entire farming bylaw. If it's,
say like
it's
animal agriculture.
yeah, I'm just trying to think of a scenario where, what type of fur farm wouldn't fall under the agricultural use. Um,
I don't know. I
That's the
never
question.
heard of it before.
yeah. that's-
Otters?
One of our earlier discussions was about how mink is has a really
Oh,
strong
yeah, we
odor.
did talk about that.
Yeah.
yeah,
I
but
don't
if,
care.
but if it's, whether it smells or it doesn't smell, if it's exempt, what's the
It's
difference?
exempt.
Yeah, but mink might not be an agricultural use. We'd have to look up definitions. To be honest with you, I would just leave them there.
Fine.
Okay.
You gotta remember, we gotta go to town meeting with this. And if
Yeah.
we're questioning it, oh my God.
Yeah, if we pull those out, they'll never get across town floor.
Right,
They'll be like,
right.
So moving on, site plan review may be required under section site plan review may be required under section 4.02 of the zoning bylaw, whether or not specifically stated in the table of uses. Consider establishing a minor or a major site plan review. Minor would not require a public hearing. Review the use of the term may and what kind of latitude that gives. Criteria should be set for when a site plan review is required.
Yeah, that was me probably. May is a very dangerous word. That could be for anything, at the discretion of who?
Right.
Building commissioner? The planning board? Planner? I don't know. That's a little too
Gray.
ambivalent for me.
Mhm.
Liana?
I think, and don't quote me because we'd have to we'd have to search the word site plan review. I think the reason the term may was used is because there are other triggers to site plan review than what was specifically identified in 4.02. I don't think it was intended to be like, yeah, hey, we'll let you know when we think it's required and when we're not, we'll get back to you on that. I think it's intended to be clear in the bylaw if you trigger site plan review. It's just that 4.02 doesn't outline every single instance that triggers site plan review.
So
then we should
we
say
say,
that.
yeah, if like site plan review may be required, whether or not like site plan review may be required, blah blah blah, if referenced in a separate section of the bylaw.
Something like that. Just
Yeah.
wordsmith that a little bit. Yeah.
Yeah, I think if you look, it's probably like it's probably table of uses plus what it says in 4.02. I'm not sure it's,
Right.
I mean, there have been other amendments to the bylaw that are probably not captured appropriately because again, this was band-aided, right? So there could be another section that was added that says, hey, and by the way, site plan review is going to be required. So I think if you do a word search, you'll see, and that'll help you kind of figure out how to fix this sentence. But I don't think it was intended to be discretionary. It was more like, hey, it's not all just in the table of uses.
Right.
That makes sense. Thank you.
One little word can be dangerous, huh?
Yep.
As an attorney, I love the word may.
I bet you do. According to which side you're on the attorney.
Moving on to X, any finding, or 10, sorry, any findings required by the permit granting authority under this section shall be in addition to and not in place of the required findings for the issuance of the permit itself. For example, without limitation for special permits, see section 1.06. For variances, see 1.05B.
Yeah.
And for site plan review, see 4.02. Yeah, Jane, do you want to? I don't think it's clear either, but what do you?
Yeah, I just thought that maybe we could word it more clearly, just so we're not trying to scratch our heads figuring out what is it saying.
Well, it's saying that if there's multiple permits, that they don't preclude each other or exclude each other. That's all. Yeah,
Okay.
it could be wordsmith a little, but I get it.
Yeah, same.
Okay.
Okay.
I'm fine
So
with that.
revise
Basically, we're saying where more than one permit is required, the applicant has to meet, the applicant has to meet all the requirements for all the permits.
Something, yeah.
Something like that. So no land or structure shall be used in a manner that is detrimental or offensive or creates a nuisance by reason of noise, dirt, odor, etc., except to the extent allowed by Mass General Law, Chapter 111, Section 125A, and MGL 243, Section 6. Review of order adjudging the operation of a farm to be a nuisance. This section allows for normal ag noises and odors, and provides the process for abating nuisances aside from these. Jane, do you want to? So do we want to keep this or you're muted. You're muted. Sorry.
There's too much background noise with emails coming in. I just wanted to include a reference to that section of Mass General Law to see if there was really a question about it. The section allows for normal ag noises and odors and provides the process for abating nuisances aside from these. So
I think it says that.
Yeah, so
Okay.
do we want to leave this then?
Yeah,
Cool.
somebody's
Yeah, I
putting a
think
big
that's, I
thumbs
think
up.
that's
I
fine.
like that.
Yeah.
What was
Yeah,
that?
a thumbs up is appreciated.
But that's
That's,
Brendan. I
that's
just,
Leanna. Leanna likes it.
oh,
And Brendan. So then moving on, wherever a non-residential district. So Jack, so this talks
Oh.
about a buffer from a residential dwelling and
oh,
lot
yeah.
lines. You had a comment on this?
Yeah, this is,
Well, Bill
this is the
can help
buffer.
with this. Every town I've ever worked in, this is a pain in the butt.
Keep in
Because
mind,
what,
this is only the highway business district.
right, but anytime you have businesses and residential districts abutting each other, you have buffering issues and
Yeah.
encroachment issues.
Well, I'll put it to you this way. Where this is only the highway business district, we've pretty much taken care of all the buffering zones. Currently, the property's been used. So I wouldn't, and I'm just thinking of town floor here. We're gonna get a lot of opposition if we try and take this up.
I agree.
Yeah,
It was just
completely agree.
topical, that's all.
Yeah, but it really isn't gonna come into play moving forward. Like I said, any of the buffer zones have already been utilized, so with the addition of one application that was just approved and the warehouse that was approved has pretty much taken away any requirements to be concerned about the buffer zone.
It is what it is.
Okay.
It'll never be perfect in my mind,
No.
but that's
No.
pretty good.
Okay. And then, yeah, vegetative landscape buffer strips shall be installed and maintained between lots. Yeah, so trees and shrubs for landscaped areas shall be of native varieties, and then we can just add and non-invasive.
Yes.
Brendan?
Oh, Brendan?
Yeah, quick question on this. So, yeah, I agree with the non-invasive. I think that's increasingly important. Any trees, shrubs, or other vegetation which die shall be replaced within one growing season. Is that for the initial planting, or is that moving forward into perpetuity? And what's the enforcement mechanism for that?
Ooh.
That would be through the planning board. And it would be, well, in theory, within one growing season, I guess.
Yeah, even the replacement would, what would,
You can't be
I
unreasonable
mean, it isn't.
to have it in perpetuity.
Lonnie?
Yeah, the planning board also isn't gonna be the one that, generally these type of items are brought forward by a resident. It isn't like the planning board's gonna continually inspect to see if we can't have the building inspector go or whoever zoning enforcement is going out there and making sure the trees grow. So usually that stuff gets unearthed by a neighboring resident or whatever. And then the board takes action. We've done it in the past. The board will take action to rectify the situation.
Lonnie and then Liana.
Yeah, so, right, there is no enforcement mechanism. The enforcement mechanism is, okay, when they want to do something else, they come in for a permit. You have to get them to redo all the stuff that's not done. And, it's going to depend. It's just going to depend on who the owner is. I mean, what kind of, we've gone through these things multiple times of the fees and fines, and then we get to court and they're not they don't uphold. So, I mean, when you look at it, it's hopefully the neighbor is a reasonable person and likes to keep his property looking good. We ran into it multiple times already.
Yeah, the planning
Liana?
board, obviously the planning board reviewing an application, that's one of the things we tend to look at during the application process is if we've run across, and we have had this happen before, run across people that developers or whatever may be the case, that we haven't had the best working relationship in the past. So we've kind of held their feet to the fire before we've approved.
Liana, you have your hand up?
No, I think someone's already answered it or asked it. Thank you.
Okay. So do we want to change this to or leave it as is?
I think just change that non-invasive piece is the
Yeah,
only.
just add
Okay.
in invasive.
Okay.
Should we reference the invasive species list, the Massachusetts invasive species
Yeah.
list?
I thought that when we first were talking about this. Moving on, where more than one category covers a proposed use, the more specific use category shall control. So yeah, what are Liana?
Yeah, I saw the question as to what the heck this meant. I think that's the question. So basically that means like if you have in your use category, it says business district and it says, I don't know, whatever that should require, but then you have a specific business list that say bank, right? If there is that distinction, you would go with the more specific use category, which would be bank. If it's just a business that doesn't fall into like one of the more specified categories, then you'd go with the broader category. Does that make sense?
Yeah. Jack?
Yeah, I agree. It's like if there's a category that says retail and then you have, I don't know, a flower shop. Obviously, the flower shop's the more detailed, specific use.
Okay.
That's fine. That's more
Okay.
than fine.
All right, moving on. So we have two subsections that seem to conflict with each other. So the first, section 4, no building or structure shall be added to, enlarged, or reconstructed to an extent greater than 50% of its area at the time of adoption of this bylaw or such amendment. No nonconforming use may change to a different nonconforming use. And then we have any change, reconstruction, extension, alteration, or enlargement of a nonconforming structure in such a manner as to increase an existing nonconformity or create a new nonconformity shall require the issuance of a variance.
Well,
Brendan?
Just speaking for myself, I think that the goal of all the zoning is to get everyone to be as compliant as possible. So if you've got an existing nonconformity and now you say you have a bowling alley and you want to open up a different type of business that's prohibited in that area, I personally would argue for keeping the no nonconforming use may change to a different nonconforming use. But the conflict I see is or create new nonconformity in part 5. So I'm wondering if maybe removing that would solve the pickle, but open to talking about that.
Jack and then Liana.
yeah, I think I'm gonna respectfully disagree with Brendan. Only because I believe state statute is 5. I think you have the right to do that to ZBA, and it's ZBA's decision, not town meeting's decision, if that makes sense. That you have the right to see if your new nonconformity is any more intrusive in the area or to the neighbors or to the town. And I believe that's true. I may be wrong about that, but I've always run on that. So
Yeah, I
actually think
kind
you're
of agree
right.
with Jack on that.
I think you're
I don't
right.
want to run
I
into
remember
trouble
that.
there. That's all.
Yeah. I think that makes sense. So I'd be okay with that. You know, if it's lessening the impact of the nonconformity by changing uses, I think that makes sense.
Or the same. And
Or the same.
that's a ZBA at their discretion.
Liana?
So I guess I didn't follow that last part as well. But I do agree with Brendan, like the whole goal in zoning is to make any non-conforming use closer to a conforming use, right? You don't want really non-conforming uses. But that being said, I think 4 is basically about like say you have a structure that's 1,000 square feet, you want to make it 1,200 square feet. You could do that so long as you're not exacerbating the existing non-conforming use or adding or non-conforming use or structure or sorry, I lost my train of thought, or changing the use, right? Number 5 is basically saying you can't create any new non-conformities, right? Because now you like say you're in the setback, right? Like you have a 20-foot setback and you're only 10 feet away, right? That's an existing non-conformity. But say you want to like increase the height of your structure, but that's not going to create an existing non-conformity. That's fine. But if you were already violating the height, the side setback, and now you want to violate the height setback, that's a new nonconformity, and you really wouldn't want to issue a variance for that. You wouldn't want to create new nonconformities. And I will say, depending on what you guys, you could really, you have a lot of leniency as to what you do with respect to nonconformities and how liberal or strict you are with them, with the exception, I think, of single family residences. There are some requirements in the statute about that. And what I will say is when I was looking up the laws on non-conforming structures and uses, like the first thing all these treatises say is like how confusing the statute is and how much litigation there is over the first 2 sentences. So that's never a good starting place. So I think you have to kind of figure out what you want to do with non-conforming uses and then write it that way. If this is it, then fine. If it's something else, like we write it and then we see if it kind of passes muster under like the existing legal precedents. If that made any sense, sorry.
Can I chime in? I'm reading this. It's interesting. I'm reading this like 3 times now. 4, the last sentence is very interesting. No non-conforming use. 5 doesn't talk about use. So this needs to be clarified. And Liana is right. There's case law every day probably on nonconformities, and it's ever changing about what the courts are agreeing to or not agreeing to. My only point is that we can't eliminate the right to go to ZBA and have your case heard, so to speak, on whether your nonconformity, whether it be structurally or use, is any more detrimental to the neighborhood. That's my only comment.
Liana?
Yeah, and again, I'm just kind of winging it here. Like, Jack's already mentioned, like the case law is ridiculous on this. I think the distinction is if it says, or creating a new nonconformity, right? If you're creating a new nonconformity, you're not entitled to get a variance for that, right? I mean, you can go for a variance, but you have to present like something that's unique, and it's not unique, the fact that you have a nonconformity. So like, you're not supposed to use a variance as like a jumping platform to like keep creating more nonconformities, right? Like unless you can meet the criteria for a variance. But I think, Jack, the other piece that you were talking about, and I think that there is some language in the statute about like not being more detrimental, like stuff like that. That's like the extension of an existing nonconformity, or the like expansion of a nonconforming use, right? So there are those criteria that says, hey, if it's X, Y, and Z, then you could do this, and if it doesn't rise to the level of being substantially more detrimental, you don't necessarily need a variance for that. By the way, I think you can get away with like a section 6. I think it's called the section 6 finding, or like a special permit. Yeah. So I don't disagree. Like this language might be a little confusing as to what we're saying. I'm not sure if we've ever had any trouble with it, but I also think we need to figure out, what we want to do for nonconformities and then write it in that way, right? Like if we're okay with someone increasing an existing nonconformity and we only want them to go to special permit for that, we could allow that, right? Like, so, but again, we'd have to know what we want to do, write it, and then see if it kind of meshes with what the existing laws are. But like I said, in this space, there's a lot of cases and a lot of confusion.
Thank you, Jack, and then Jane.
I'm, I think Liana and I could talk about this all day. Uh, it's kind of getting back to me to the other section where you're talking about a more specific use. And I've seen cases, Liana, where I don't know, I'm making this up now, but there's a liquor store or something that's non-conforming and somebody wants to convert it to a flower shop. That can be heard in front of ZBA as that nonconformity is no greater detrimental to the neighborhood. I've seen that. So uses can be changed in nonconformity provided they're not more detrimental. Maybe statute isn't that clear on that. I don't know, but I've seen it happen. I just, my whole point, we could talk all day about this, is that we should try to get as clear as we can here and that as up to date to state statute and state laws as possible here. And there's some very good examples I could send to you in other towns that I've
Yeah,
worked in that have redone this.
why don't we do that? Let's clarify this for the next meeting and see if we can get maybe better language from another town that aids us in, because it is kind of,
It's important too.
when you think about it, it does kind of conflict. So we want to remove any ambiguity.
Yeah. Jane?
So my understanding is that in order to approve a variance, you have to prove a hardship. And kind of the first rule in hardships is it can't be something you created yourself. So if you create a new nonconformity, how can you issue a variance? It
Well,
just doesn't make any sense to me.
Yeah, well, now you're thinking of different ways of doing variances. With use variances, it's a lot different. Um,
Yeah, it really doesn't, they
um,
really don't have the stigma of,
I'm not an expert in this, so I'll do whatever the group wants to do, but
Dylan, and then Liana, you still have your hand raised, so. And Dylan and then Lonnie.
you there, Dylan?
Yeah, Dylan, we can't hear you.
it's that laptop she has. It's a mess.
Lonnie?
I think that the big piece is what was just said at the end there is we do allow use variances in Mendon, which is a little odd for, again, from what I'm told, a lot of towns don't do that.
That's true.
Did you say we allow use variances?
Yes,
Does our bylaw
Should
say
we?
we can allow them?
yes.
Okay, yeah, as long as our bylaw says we can allow them, then yeah, I think that is unusual because but if it's stated in our bylaw that we can allow them, then we're fine. I didn't realize our bylaw said that.
Yeah, I didn't either, Liana. It's unusual. Yeah.
Well,
Until
maybe you
someone
could-
gives you.
Maybe we could consider removing it, and that would get rid of half of this.
I don't think that that's a good idea.
No.
This leaves us an opportunity. Look, yeah, if we just want to be strict, but if something ever came down the road that was that even if the town agreed upon it, and there was no pushback, and it was a good idea. Excuse my cat. That we could at least we have the option. It's there for us to approve. We don't have to.
All right.
Dylan had a good comment. What does the first sentence of 4 have to do with the second sentence? So, to clarify, no building structure shall be added to, enlarged, or reconstructed to a greater extent than 50% of its area. Stop. No non-conforming use may change to a different non-conforming use. Yeah, I think Dylan is right. That those should be two separate.
Yeah, if we're gonna keep it, they should be separate. Yes.
Yeah.
It's also specifically talking about non-conforming buildings, correct? Because it's in this section.
Well, see, that's a good question, isn't it?
No, that section says non-conforming uses and structure.
Yeah.
Yeah. So that would mean a non-conforming structure can't be enlarged greater than 50% of its area.
Should we clarify that then? I think this needs a whole rewrite.
I think so. I think
yeah.
so too.
Okay. And that's
I'll throw you a couple examples. The last rewrite I did was probably, albeit 8 years ago, 7 years before I retired. And we had one of the preeminent land use attorneys write the non-conforming section. Now, it's probably changed, but I can give you at least something to start with.
yeah. Before we move on, Liana.
I was gonna say two things. Number one, I don't disagree with what everybody's saying that this section needs modification. On 4, I'm wondering if that really is trying to get to uses and trying to get to basically what we think is the threshold for too much expansion of a use, right? Because you can't do a new building, right? That's too much of an expansion of a use. But if you're changing existing, so again, I'm just trying to throw out there, maybe that was the attempt at getting to what we thought was a threshold of an okay use expansion, right? If you're doing 50% more of that use, that might be there. So again, I don't know that that's why it was there, but that may be how it ties into the second sentence. And then secondly, I just wanted to say that I don't think Jane was incorrect earlier when she talked about hardship for variances, because I'm looking at the grant of use variances under section 105 for the Board of Appeals. And while we do have that right does pull in the substantial hardship, the soil condition, shape, topography. It's for exceptional uses only. So I think there is still quite the burden. It's not just, someone that has a non-conforming use, they're the liquor shop and they want to change to the flower shop. I don't think they would meet those criteria for a use variance. So again, just my personal opinion. I don't know, the laws on these particular topics, but I wanted to throw that out there since Jane had raised it, and I think she's not wrong based on the way our bylaw is written.
Thank you. So yeah, I think this is something that the 4 of us, the staff, will do a rewrite.
Yeah, actually, I just noted there's a CPTC guidebook on non-conforming uses and structures, module 7.
I found that guidebook as well. It's fantastic. I started reading it, but it's like 60 pages, so I couldn't get through it all, but it definitely has a lot of information. I'm not sure when it was dated. I did see they had some case laws of 2014. When was?
Oh, that's not bad though.
Same one.
I'm on it now. I'm trying to find a date on here. But.
Yeah, I didn't see the date quickly, but when I was looking at some of these things on non-conforming uses, I saw a cite to a 2014 case, so I know it's at least as old as 2014. But that is a fantastic, I was looking at it and it is very well written.
There's ones as late as 2016.
Okay.
Almeida versus Ruta was 2016.
All right. Well, thank you. We'll definitely consult that handbook. And then Jack had another comment. Just
They did?
Yeah. What does a variance make a use conforming?
No.
Okay.
So I think that answer is yes.
Leanna's right. I mean, I'm actually on a circuit of I mean, this is being litigated everywhere. Holy cow.
Yeah, I know,
it's
crazy.
Like you go on for pages here.
Yeah, I was trying to prepare for this meeting and be helpful. And as I got into it, I said, okay, I can't even be helpful because all of this is all over the place. But I think the question that you just asked about whether a variance makes it not conforming, I think the answer is actually yes to that, because in this same handbook, it talked about like why you might not want to do a variance, because there are certain protections afforded a non-conforming use under section 6 that are not afforded to somebody who's been granted a variance, right? Because if you're granted a variance, you're not non-conforming in the statutory sense, right? You're technically not conforming with the zoning bylaws, and you're getting basically a pass to be not conforming versus being statutorily not conforming, if that makes sense. But
no, that doesn't. It's a legal nuance, but I got that. Yeah.
Right. And there it talks about how there are certain protections of being statutorily non-conforming that you don't get if you're variance non-conforming, right? And then it also talks about stuff like, well, you could give a variance for like a new non-conformity or like an increase in a non-conforming, but maintain the being a non-conforming structure or use for the existing. I don't know. Again, as Bill mentioned, like he's just scrolling through now, it's insane. So maybe you could find a really good bylaw that has like this a little clearer, and that would be helpful at least to start from, instead of trying to throw like darts in the air and hoping we hit something right.
Yeah, I'm on an article here from Cornell Law School. They talk about non-conforming use. I'll get to the gist of it here. Without non-conforming use, a business may have to level their entire business just because an area has become rezoned as residential only. To avoid this predicament, city governments weave non-conforming use clauses into zoning laws that grant some exceptions for property developed for the regulation. Non-conforming uses come with limitations. Often non-conforming property may not expand non-conforming use in any way or change property use at all unless it conforms with new zoning regulation. So I think that's kind of where we're headed. Did that make any sense, by the way?
Yeah. I think you're
Yeah.
gonna find the next sections are pretty more straightforward.
Yeah.
These are right out of statute. These haven't changed.
Yeah. So yeah, let's move on. So the next
I'll send
thing
you what
we're-
I got. That's all I can
Yeah.
do.
and we'll meet at some point before the next meeting. So we went through the table of uses. We might not, we have like 15 minutes left tonight, before Liana has to jump off. So we might not get, Jane and I kind of anticipate that this section might take more than one session to get through, just because it's very long. It's honestly like the longest section in the whole bylaw, and we probably should break out a lot of it into separate sections. It seems like a lot of stuff was just put in here. Whereas in a lot of other towns, when they have a new bylaw, they just stick it at the end. This one, it's put in section 3. So I was kind of looking at the use table with a village center district in mind. What would be things that would be suitable for a village center district? But we have comments regarding all sorts of things. So those are kind of how my comments were oriented, because Jane already did a pass when I looked at this. So under residential uses, I guess I was wondering, do we want to consider allowing multifamily dwellings if we're going to do a village center district? So currently there's only single family and 2-family dwellings. Do we want to permit something like a 4-plex or a triple decker? And also, do we want to allow like mixed use development? And this could be in a village center district, or it could be elsewhere in town. Lonnie?
Yeah, I think in the mixed, so when we talk about the village center again, until we figure out what that size is, our current village center is just densely done and is currently over 4, right? What's in the rooming house, Bill? Is there 6 in there?
Yeah.
Yeah, something like that. So I mean, obviously that's pre-existing, but I think that we shouldn't get away from that the multi-use area even throughout town. I've just seen it, and I've only really seen it down south. I don't know that I've seen it up here much, but I'm sure it is somewhere where they have some businesses down on the ground floor, and then condos above those businesses, whether they be retail or what have you. They kind of plop them up as like, hey, there's a plot of land, and all of a sudden now you've got a place with nightlife and retail and restaurants, and then all these cool condos above. Again, I don't know if it works here, but
Well, I think this is something we've been talking about for a while. Lonnie is, and it's come up before, that mixed use is something that Mendon needs to seriously consider, obviously. one perfect example of a mixed use, is in the Arma, where we have commercial and residential mixed together. I don't think we should limit it. And to be honest with you, with the nature of what's going on with the state of Massachusetts, I fear that it's not going to be long before some of these things are jammed down our throat anyways. I heard some of the new stuff that's already hedging this way from the state. And I'm a little, I'm not surprised, but it's probably going to further change. And Jane's right, we should be looking at, or Gabe, whoever mentioned it, more multifamily, whether it's a fourplex instead of a, once again, we're talking about more affordable housing for community members that currently reside here. We do already have one in town, I believe.
Yeah, but unless we can say that space is only going to be used for residents of this town that don't want to leave, that doesn't.
That would never pass muster.
Right, that's what I mean. So the longer we can keep that away, in my opinion, is that until it is forced on us, let's just keep it away.
All right.
I totally agree, Lonnie.
Yeah.
And examples of mixed use
Agree.
up here I've seen is on 126 on the Ashland Framingham line. I don't know if anybody remembers Marconi's. No.
Yes.
Yeah, right on 126 near the Market Basket in Ashland.
Yep.
Right on your way to Framingham. On the right-hand side, there's business on the bottom and apartments or whatever on the top. It looks nice if we had to do a mixed use type of thing, but certainly there's communities that are pushing back on the state asking us to provide more apartments or multifamilies. I think I agree with Lonnie. The longer we can put that off, the better.
Sounds good.
Also, Medfield has really pretty downtown village district mixed use stuff too,
Yes.
but not 6 unit apartment buildings in that village district in that area.
Yeah, and I
Just
mean, yeah. I mean, the thing too is if we're talking about a village center district, I would be looking at, I would be, for somewhere like Mendon, I would be thinking about like a 2-story building.
Right.
Like with
Well, we have height requirements, so that's all it could be anyways.
Yeah. Yeah.
Well,
Jack?
we would say the post office has that, right? Don't they have
A little bit.
business
Right.
downstairs and apartments upstairs? I think
Correct.
we fulfill that requirement. And I agree, Lonnie, we want to, if we're going to provide housing, it would be nice to be able to provide affordable housing for the people in our community, our first responders, our teachers. There's plenty of people in this town that would like to stay and teach here and work here we can't afford it.
Yeah,
but there's no,
that's unfortunately that would never pass.
yeah, it just needs to go in the lottery, but
I
you
know.
don't preference if there is even
Right.
a lottery. So to use that as an argument, I feel like we're not being truthful. The other thing we have to look at our height requirements, though. Keep in mind we didn't have a ladder truck, and now we do.
But we're still not lifting that height requirement.
Jack, and then
Linden
Brendan.
doesn't need anything over 35 feet.
Yeah, Gabe, I know you didn't do this on purpose, but I think we should keep with the spirit that we're not going to go into these new districts yet. Let's try to get
Okay.
through what we
Totally.
got.
Absolutely.
We could, we're going back to this village and back to mixed use, and everybody's right, but Bill and I talk
Yeah.
about this almost every time I see him, and he's right. It's something. It's already happening, whether we like it or not. But
yeah, we can move on because Jane has more than Jane's
can we
comments
get
are a
back
little
to the
more
single
substantive.
family though, if you don't mind?
Yeah.
Well, Jeff, one thing though, there are communities, I'm sorry, but there are communities in this state that are not going to be developing. If you're saying yes, the state wants that, but if you look at a Dover or a Sherburne or a Milton, these towns are not
See,
laying down. You know what I
Yeah,
mean?
and,
They want to keep their community the way
but
it
if
is. They don't.
but
But
We
if-
Lisa,
don't have MBTA next door to us. We don't have a train.
I,
the
yeah,
truth of that is, you're right about that, but every single one of them have lost all state funding. No DPW funding, no cherry sheet funding.
any cherry sheet.
Obviously,
funding-
they can afford it, but they're gonna go into receivership eventually.
That's
We could talk about this all night.
Well,
and for
I
them-
wanted,
okay.
I wanted to talk about the single-family dwelling and that we don't allow it in either highway business or general business. This is just one of my little nuances in our zoning. Is on Cape Road, we have highway business with a host of single-family houses there
Right.
that are now non-conforming. They weren't before the zoning was
Well, they were,
changed.
they were pre-existing the
They're
zoning.
now they're pre-existing, non-conforming. And the other side, and Lonnie knows about this, is that they are now receiving water from the town of Hopedale, and Hopedale will no longer allow water to any commercial use. So they're zoned commercial. They can't convert to commercial because they can't get water, and they have to stay residential. So I just think
They don't
that
have to stay
it's an
residential.
unintended consequence that they're stuck with this. That's my only point.
So do we want to
I'm
consider
not sure.
changing that back to yes, or
Maybe by special permit, I don't know.
Why
Leo-
can't we just say, can we do something along the existing ones can remain residential? I mean, depends on if the person wants to sell it and
Well,
It's-
that happens anyways, because it's pre-existing. I mean, we don't have to put that in here. I
Yeah,
mean,
but
that-
Lonnie's right. If you were trying to sell your house in that district, the good lawyer's
still
gonna say,
residential
wait a
if
minute,
it's-
you're non-conforming.
no. You can still sell that as a residence.
Yeah,
I
as
know,
long as you
of
don't-
course you can.
Yeah, as long as you don't change the use, and if they go commercial, if they can't tie into the water line, I put a well in. Most of them probably already have wells. To be
Yeah,
honest,
it's
I
one
just
of
don't
the
see that as a real.
catch-22s, that's all.
Liana has had her hand raised for a bit.
Yeah, I was just gonna try to figure out what the problem is we're trying to solve, and I'm not following it very much, but I am a little concerned about just carte blanche changing single family dwelling to a yes in any of the business districts, because our business districts are so small. Like, I think we
Yeah.
want to encourage
Mm.
business there and not more residents. But that's my own personal opinion, but I do empathize with these landowners and the fact that they're non-conforming now. And so if there's something we could think about and I don't even know what we need to solve for them, but if there really is an issue that they're having because they're now non-conforming in that district, if there's a solve we have for them to fix whatever it is they're struggling with, I'd rather try to write that solve versus allow residential carte blanche in a general business or a highway business. Even with a special permit, I wouldn't want to see it.
So maybe.
Yeah, I mean,
Maybe we
That's why
could
we
talk
did that
about
originally.
an overlay for them to allow it just in those certain instances, but we can do that down the road,
Mhm.
Just
Okay,
wanted to bring it up.
we only have 5 minutes left. I'm sorry we got on a tangent. But like I said, Jane and I anticipated this would take a couple sessions. So yeah, so kennels, first comment from Jane. Footnotes 20 and 21 state that kennels must be licensed by the Board of Selectmen. Consider where regulations for kennels should be zoning or general bylaws. Lonnie?
So the use is the way it's always been, is the use of the kennel has been through the zoning or planning. And then just the amount of the kennel license itself and dog counts and things along those lines are all set by the select board with the animal control officer. Obviously, they work in conjunction on that. And then there's some state law. Well, I don't even know that it's been adopted yet. I know that there was a big to-do with what it was Camelot before. Now it's Paws Bed and Biscuit there. I believe he's gone through all of the. It was a little contentious there for a bit, I remember. But then I think everything got worked out. But I think there's the difference in the if, again, just trying to clarify the difference there of what is being done by the two different groups.
Thanks, Lonnie. Yeah, that's correct. And the law you alluded to, I think, is Ollie's law, and it's just taking effect.
All right.
It seems like Jane was trying to let us know, though, that there might be more licensing type language in the zoning bylaw. Is that, Jane, what you're trying to get at? That maybe we need to pull out, but not that we need to change who does what, Lonnie, but maybe we're saying stuff in the zoning bylaw that we don't need to say. And I can't see footnotes 20 or 21, but that's the way I interpret Jane's note.
Yeah, Gabe, can you scroll down to the footnotes
Yep.
20 and 21?
At the back of the section. Yeah. So in residential districts, the owner of the kennel must live on the same property where the kennel is located. The breeding, training, and raising of dogs is considered an ag use if it meets the requirements of MGL 40A Section 3. However, if the dogs are not owned by the kennel owner, the breeding, training, and the raising of dogs is not considered an agricultural use. All kennels shall be licensed by the select board.
I see what you're saying. Just reference the town bylaw in that section. Is that what you're saying?
The general bylaw?
Yeah.
Yeah.
So does the general bylaw talk about the requirement that the owner of the kennel has to live on the property? I'm not familiar with what the general bylaw says on the kennels.
I would have to review that.
Okay.
Have it up.
So
Yeah,
maybe that's what we
one-
need to do, is see what the general bylaws say about kennels and then decide where it's most appropriate to include something like this.
It is rare to have that kennel bylaw in the general, but that's something that happened many years ago, so
Yeah.
it's not gonna be able to unearth that cat
I
now.
believe the intent of that was to just let folks know that, hey, you have another stop for your kennel other than just.
The planning board, I got you.
Yeah. Yeah, that
It-
makes sense.
Another question, is there any reason or desire to have a kennel in a highway business?
Yeah, I don't think that's a totally crazy use for a highway business. I mean,
Wait, which column is highway business?
Well, I think it's
That's
because
four.
we were discussing that the kennel owner had to live on site, so
If it's in a
creating
residential district?
Yeah, well, it's creating a residential environment in a commercial district.
Not necessarily.
Not necessarily,
But
no.
it's saying, the footnote says, if it's on a residential, you have to. We don't allow it in the highway business, but I don't see why we wouldn't. That would be the.
Well, I agree. I mean, if you
Yeah.
want to change that to PB, that's fine.
Yeah, I
Yeah,
would agree with
it
that.
just makes sense, more and more kennels all the time.
There's some nice ones down in, Plainville right off the highway district there. So makes sense.
Camp Bow Wow in Bellingham's right on the highway.
there's one on the Pike, right? You can see it going into Boston. All right, so it is 7 p.m.
Motion to adjourn?
Yeah. We still have quite
I
a few
second.
notes on this section. But
Oh, we did so well, too.
Well, this is one of the largest sections of the bylaw. Anyway.
Yeah.
Mhm.
So do we want to meet on the 21st?
Is that 2 weeks?
Bill, when is next week? When was your thing? Today?
2 weeks. Next week I have chemo, so it's got to be 2 weeks from tonight.
Okay.
Okay.
21st?
So if that's the 21st, we'll call it the 21st.
Mhm.
Perfect. And we'll be sure to, Jane and I will get the agenda sent out. We'll try to do it like the Monday before, just so that everything's lined up. And Jack and Dylan, we should meet at some point before then. Maybe the week before. We'll figure it out.
Yeah, and I'm gonna start, some of these issues that are coming up, I'm gonna start looking through what other towns are doing. And seeing what it looks like. And I'd like to review that CPTC guideline. Non-conforming uses too.
If anyone is so motivated too, so all of section 3 is available. We sent it out, I think, before the new year. Feel free to, if you want to send staff an email, if you have anything you come across that you want us to see before the meeting, that would be.
Did you send this edited version out with the highlighting and stuff?
It should be when I should have sent it out with when I sent out the agenda and stuff. So
Yep, I got it. I have it open.
So if anyone's so motivated, that would be helpful.
Sure.
I'll
do that.
I was just gonna say, I do have to run, but also wanted to say, I don't think the laws have changed since I was last on a board, but I think just a reminder, I know Gabe, you were suggesting to send it to staff to you, just a reminder not to CC everybody on the committee, because that could be a violation of the open meeting law. So when Gabe says send it to staff, that means Gabe
just
and Jane, not the entire committee, or we could run afoul of open meeting laws.
Yes,
Thank you, Liana.
Let's not run into the open meeting law.
One other thing too, I just opened a ticket for myself that I'm going to create a zoning bylaw review committee distribution list. So it'll just be easier when you are sending out a bulk, you can send it right to that.
Perfect.
That way you don't have to go back and look in everybody's email that who's on the committee. I think that's all I had.
Do we have a motion?
Yep, motion's on the floor.
Second.
Do I have a second?
Chanel second.
All those in favor?
Aye.
Tenio, aye.
Chanel, aye.
Ambrosino, aye.
Yep.
More aye.
And I think that's pretty much it.
Thank you, everyone.
Thank
Have a
you,
good night.
everybody.
Thank you.
Good night, everyone.
Good night.